2008, Abigail Fisher was denied admission to the University of Texas at Austin. She then sued the university, claiming the admissions process was discriminatory because race was taken into special consideration and she was disproportionately affected by this because she is white. But to understand this case, let's jump back to 1992, when Cheryl Hotwood was denied admission to UT's law school. So she then sued the university, claiming that the admissions process offered an unfair advantage to minorities. Sound familiar? Well, this case, which was also testing affirmative action, went to the Fifth Circuit Court of Appeals, where in 1996 they said the school, quote, may not use race as a factor in deciding which applicants to admit. So, a year later in 1997, in protest to the ruling, Texas House Bill 588 was passed, which created the top 10% rule. This was an effort to promote diversity by automatically accepting the top 10% of a high school's graduating class, while at the same time avoiding explicitly using race as a criteria in admissions. In 2003, however, the Hotwood v. Texas ruling was made null and void by the Supreme Court, where in Grutter v. Bollinger, the court ruled that using race in admissions in order to, quote, obtain the educational benefits that flow from a diverse student body is, in fact, allowed. So, let's go back to 2008, where Fisher is again testing the legality of affirmative action. The case got underway in 2009 when the United States District Court for the Western District of Texas ruled that the university's admissions processes were in the bounds of the law. The case was then appealed and in 2011 was heard by the Fifth Circuit Court of Appeals, who again stuck with the precedent set by the Supreme Court and again ruled in favor of the university. Again, this decision was appealed. In spring of 2012, Fisher graduated from her second choice college, Louisiana State University. Then, in the fall of the same year, the Supreme Court decided to hear the case. The court's opinion was released in summer of 2013, where the court claimed the Fifth Circuit Court did not apply so-called strict scrutiny in their case, and so the Supreme Court vacated that ruling and remanded, or essentially sent back, the case to the Fifth Circuit Court. So they didn't actually make a decision on affirmative action itself. So after rehearing the case, the Fifth Circuit Court revealed their new opinion, still siding with the university and upholding the use of race in admissions. However, even with its most recent decision, there's a chance the case could not be over. The Fifth Circuit Court's ruling could be appealed yet again by Fisher, and if the Supreme Court agrees to hear the case another time, there could be yet another chapter in the story for Fisher v. the University of Texas.